Good morning, Mr. Oleski.
Stephen Oleski for the defendant's appellants here. The defendant's statement of facts shows just why the legislature enacted Chapter 231, Section 6F. This is that type of egregious lawsuit in which the legislature intended that punitive fees shall be awarded upon a finding by the trial court that all or substantially all of the claims advanced are insubstantial, frivolous, and not in good faith. The single justice erred in vacating the trial court's 6F finding and award because of on two bases. First, he erroneously concluded that the 6F standard, all or substantially all, meant that any pebble the plaintiffs threw in the path during the case, no matter how small or insubstantial, meant that no fees should be awarded.
Is that really, I mean, the way I read the single justice's decision, he was saying that all or substantially all means all or essentially all. I think he uses the word essentially all.
Yes,
And so if you accept for this part of the argument that the claim about of the fiduciary duty claim had some validity, is it so wrong to say if you've got three claims and one of them has validity that that isn't all or essentially all? Or do you disagree with the essentially all piece?
well, he conflated all and substantially all to mean essentially the same thing. I think if you recognize that the record's quite clear that the fiduciary claim was dismissed by Judge Burns
I do, but,
at the outset of the trial.
Right, I do, but that's sort of your last argument about it. You know, it should never have been found that it had any validity at all. So I'm assuming hypothetically it had some validity. So if you do that, are you saying that if you've got three claims, one of them has some validity, the other two don't have any? I guess your argument is, at the very least, you should get the fees with respect to the first two.
That would be true, but we say that the fact was that even the single justice appears to concede that the business opportunity claim was meritless. He said it wasn't frivolous, but he seemed to consider, as the panel clearly had earlier, that it was meritless. In that case, we don't think a two-thirds, one-third analysis really works. It's the great majority of the claims are frivolous and insubstantial. This one,
and also not just meritless, but I thought the trial judge also found that it was brought in bad faith.
yes, she did, absolutely.
She did,
There's a critical credibility finding.
Exactly. She found it was frivolous. So you say the appeals court found it was meritless, but she also specifically found that it was brought in bad faith.
Yes, she listened to the testimony of one of the plaintiffs, a man named Saul Teal, on this point, who said, "Well, I believed I had a good faith basis," and she specifically found that that was an incredible statement, and she set it aside and rested in part her findings on that basis, that she did not believe what he said. And she said, when you take away that subjective belief, which anybody can have at any time in any case, what's left was no evidence that was presented by the plaintiffs after 4 years of discovery, 33,000 pages of documents produced by my clients, to support any one of the claims.
Mr. Oleski, the all or substantially all is obviously in play here.
Yes.
Right? There was a motion to dismiss, and then there was a motion for summary judgment, correct? Which was Judge Houston's decision?
Judge Houston's decision came at the very outset of the case.
PI.
The plaintiffs brought a preliminary
it was a preliminary injunction, right?
request, and he denied it on the grounds that they had no likelihood of prevailing on the merits. That's 4 years before the case is tried. Then they brought a summary judgment motion to test their business opportunity theory, as they said in their affidavit, and they lost that.
I'd like to ask you about something about that. What is confusing to me is the appeals court said that the law wasn't clear until Chokel was decided, but Blank had been decided previous to that. But Blank and Chokel only deal with shareholders. And wasn't it always clear even before that partners owed a fiduciary duty to each other?
Yes, that goes back to Donahue and Rod,
Right,
which
so
is the seminal
I don't
Massachusetts
understand
case.
why everybody is so hung up on Chokel and Blank. Hasn't it always been the law, for a century, that partners owe each other a fiduciary duty. So we don't need to look at Chokol and Blank to see whether it was clear.
No,
that's-
all Chokol and Blank add,
Is that
importantly, is that you can cabin those duties
Right.
by a
Right.
contract, which has been
Right.
the law in Massachusetts, we suggest,
Isn't that
Right.
the
for a long
point?
time.
I mean,
But that's what I'm-
sorry, nobody's contesting that your clients owed the highest fiduciary duty, correct?
Correct.
And then what they say is, let me tell you the domain in which we owe you the highest fiduciary duty. It is 23, what's the street address? 23?
East Street.
23 East Street in
Yeah, East
Cambridge.
Street. So it's 23. And with respect to 23 East Street, we owe you the highest fiduciary duty, correct?
Yes.
Nothing unclear about that.
Yes.
And, oh, by the way, and affirmatively, we don't owe you any duties with respect to the rest of the development world, correct?
That's right. The trial judge found that, and the merits panel of the appeals court found that. And the merits panel said, setting aside Chokol, forgetting about Chokol, it's absolutely clear on the trial record that this is a single-purpose entity that's all about and only about 23 East Street. And they separately affirmed in 7 paragraphs on that basis, having put Chokol to one side.
Mr. Lesky, could I ask you from a business, I mean, this is very hypothetical, but from a business point of view, if you advising your client were incorrect, I'm not looking for attorney-client, but in other words, if in fact, what is the import of construing the contract to mean if it's an adjacent property or it has access to parking or a bridge or whatever the heck it is, what does that mean? From a business point of view, that your clients would have had to include these people in a new limited partnership?
That seems to be the plaintiff's theory. However, the trial judge found in both her merits finding and her 6F finding that if there was any opportunity, which she said there wasn't, and the appeals court agreed because it was a single-purpose entity, it was a partnership opportunity, not an individual opportunity. And the plaintiffs never asserted that it was a partnership opportunity, just that it was theirs. So the case...
There was language, though, in the agreement that in addition to 23 East Street, the partnership could invest in other properties, right?
The language was essentially in, I think, Section 4, and said in substance that the partners can treat with other real estate in order to effectuate the purposes of 23 East Street. Trial judge looked at that in the context of the entire agreement, ruled on the eve of trial in our motion in limine, which is essentially a summary judgment motion, and then reaffirmed in her 140 findings of fact and 45 conclusions of law and the merits that what that meant was, in the context of the whole agreement, that they could do whatever they needed to do to make 23 East Street an effective operating business property. And they did that. There was substantial evidence they did that. They made it a success. And everything that they did was fair and reasonable, judged under any fiduciary standard.
But you would also say, I take it, that the specific provision that the Chief Justice referred to about, each of the general partners can do what he wants with
Yes.
respect, sort of trumps that somewhat vague general language.
Yes, the trial, Judge Burns found that, the appeals court found that it was always understood, it was right in the partnership agreement, that these general partners were going to go out and make other investments. And they did make other investments, the 2 that are referenced and additional investments beyond that. But that was always the deal from the beginning and went right into the partnership agreement.
Mr. Oleski, the statute says wholly insubstantial, correct?
Yes.
If one knows or anticipates or has a belief that the claims are wholly insubstantial, would one, in the normal course, move for summary judgment? I'm talking about your side.
Well, when the original summary judgment was brought by the plaintiffs, they proffered, I think, 245 allegedly materially undisputed facts, many of which were plainly disputed. I made a tactical judgment that I was in the Superior Court, that some of the claims were going to have to be tried, that it would be very costly to bring a summary judgment motion on one issue, the business opportunity issue. It would be better to wait until we had a trial judge who could focus on the case and deal with that issue. Judge Burns was the rise. She took control of the case, which had been drifting for 4 years, brought it to a conclusion, took my motion in limine, which in the alternative was summary judgment, and decided it effectively because she had the whole record before and she knew she was going to try the case. That seemed to me to be the economical and sensible thing to do for my clients and for the judicial system.
If you're relying so heavily on a contract, though, correct? I mean, where's the business opportunity? If the contract knocks that out, in other words, you don't dispute that under Donahue there's a fiduciary obligation, and you're saying, yes, I acknowledge, but it cabins it to this one
Yes.
development. If you're relying, I mean, so what are the business what are the facts of the business opportunity that precludes summary judgment?
Well, the plaintiffs were claiming that there were oral assurances that had to be taken into account at trial that they could invest in other properties, and that's where Judge Burns sat and heard them and said, I disbelieve your testimony in the totality of the evidence I'm hearing. That's not, you could not have had that good faith belief. You were well counseled, you're sophisticated businessmen, you all have MBAs, you run companies, you had 3 lawyers doing the deal for you in the first place. It's just incredible, she said in essence, that you would say you had a good faith belief, that they told you orally that you could do other deals and that would trump an express provision, I think it's 13.2 in the partnership agreement, that they were allowed to do other deals. That's not credible.
But explain this to me. I thought maybe these claims are smushed a little bit, but I thought she essentially, just prior to trial, dismissed the so-called business opportunity claim. Is that the one you're talking about
She
now?
did, but then the plaintiffs insisted on trial, one of the reasons it took 9 days, on trying to put in evidence of the business opportunity. And she had never had the opportunity because she ruled on the eve of trial to give a full exposition of her reasoning for finding that the business opportunity claim, the fiduciary claim, was meritless. And so she did that in that decision, and she did it again in the 6F finding.
Is there anything in the statute that you, in 6F, that might indicate permitting the award of partial fees? Because there's an argument here, remand and allow partial fees. Yeah, I know, and it's your argument, so I'm asking you, what in the statute backs you up as to partial fees?
I think that 6G, which is the reviewing statute, contemplates a partial award. We're not fundamentally advocating for a partial award because we don't think the case is sufficiently close, as I've already
You
said.
also cite Emerson, and I mean, there's a couple of cases
Yes.
which have
in which you've done that, the Hahn case. So it could be done. We think the overwhelming burden of what happened here, both the 36-page merits decision and then the 16-page decision on 6F by Judge Burns, suggest that it's not that close a case, that there should only be partial fees. Judge Burns had 11 pages of specific findings in her 6F decision. The single justice reviewing under 6G swept that aside, saying only and enigmatically, opaquely, well, I find there's not support on the facts and the law for her decision. Her decision rested on the trial record. It rested on the 6F findings, and in effect, she incorporated by saying, I rely on the trial record, the findings from the trial into her 6F decision without repeating them all. So there was a huge factual record, including very damaging credibility findings against the plaintiffs, all of which the single justice essentially swept over by saying, I don't think there's legal and factual support for what Judge Burns did. He had an obligation to identify what were at that point settled fact findings if he thought that somehow Judge Burns was wrong, the merits panel was wrong, that somehow he could look behind those findings, which I think Danger Records suggests were settled at that point and had to be taken as settled for the benefit of the litigants in the system. Minimally, he had an obligation to identify what the fact findings were that she made, which he said essentially required him to set aside a finding that they did not act in good faith.
Mr. Lesky, can I ask you this? It is not unusual to, when one is arguing essentially position, to say, I'm entitled to all of my fees, but even if I'm not entitled to all of them, I'm entitled to part of them, right?
Yes.
Did you actually make the latter argument?
Not to Judge Burns.
And what about to the appeals court?
No, essentially we argued to the appeals court that it should affirm Judge Burns.
So if we decide to look can we look at the question?
I believe you could look at the question, but I hope, as I've said, that you will
No, I
not
understand
look so
that, but I
deeply
just-
that you don't affirm Judge Burns as to the totality of the fees. But you could, because the error of law here by the appeals court on the 6G review is fundamentally setting aside facts that have been twice settled, first by Judge Burns' comprehensive findings and second by the appeals court. Pretty summary affirmation, and if you look at the appeals court merits finding, they praise Judge Burns for her comprehensive opinion, say that it's fully supported by the findings of fact and the conclusions of law, and then you get to the single justice decision, and it seems as if you're looking at two different templates and that the first doesn't really align with the second without good cause.
Justice Gorsuch?
You're arguing both at the moment, right? Or are you having a separate argument for the second case?
No, I'm content to rest on our brief for
I
the
just
second
had one
case.
question. What, and it's probably in there, but could you just articulate to me, what, if anything, is the difference in the standard, do you think?
Well, you've said both that the appellate rule and Chapter 211 apply, and also that 6F can apply to appellate fees. The difference would be on the rule side of it, that there's more discretion that the appeals court has in passing upon appellate fees. But if you apply 6F, which you yourselves have said can apply to an appeal, that's a shall standard, in which case fees shall be awarded upon the proper finding.
Thank you, Mr. Oleski.
Thank you, Honor.
Mr. Green, good morning.
Thank you, Your Honor. Good morning, and may it please the Court. Lawrence Green, joined by Michael Shagru, representing the plaintiff appellees. This is not the rare and egregious case in which fees should be awarded. Under danger records, first of all, under 231-6G, the determination that was made by the single justice was a de novo determination. The single justice,
And that's the standard.
that is the standard, Your Honor.
Right.
And it's very clear between 6G and danger records. I'm quoting from 6G. The court deciding the appeal shall review the finding and award, if any appealed from, as if it were initially deciding the matter, clearly a de novo standard, and may withdraw or amend any finding or reduce or rescind any award when in its judgment the facts so warrant. That is, in essence, what the single justice did here.
Doesn't danger say that the subsidiary, where did Judge Kafker reverse any factual findings, and could he have reversed factual findings of Judge Burns?
Judge Kafker decided, in essence, as a matter of law, that the all and substantially all test was not met, for reasons that I'll get into in a little bit.
But
Judge
he did not-
Kafker had every opportunity to say, I reject these findings, I accept these findings. He didn't need to get that far. However, what is instructive is that the findings were, we believe, at least implicitly rejected in part by the appeals court. If you look at the full panel's decision, footnote 3 of their decision in the co-appeal here, the appellate issues appeal, the appeals court said that there was potential merit to a second claim, not just the first claim, the corporate opportunity claim. There was potential merit to a second claim because of an issue of full disclosure not having been made, an issue of non-disclosure. We have then Judge Kafker on a de novo review, having everything there from the lower court, making his decision de novo, which was what he was entitled to do. Now, this court, in turn, pursuant to the danger records test, says, as you'll remember, in danger records, there was a question as to whether a 6G determination by a single justice could even be reviewed at all, given the language of the statute. And in danger records, it says the term final in 6G must be given some meaning, and it connotes that whatever form of review is available must be extreme limited scope. Then this is the key language at page 24. We therefore conclude that the underlying factual findings adopted and accepted by the single justice are to be treated as final and are not themselves subject to further review, Only errors of law committed in connection with an award under 6F may be corrected on appeal from the single justice decisions under
But
6G.
that's my question. Where did Judge Kafker not adopt or not accept the findings of Judge Burns?
Judge Kafker, in essence, said that there was sufficient merit to the opportunity claim, which we believe
That's a
was the
legal
primary
that's a
claim in the
legal-
case, both as a matter of fact and as a matter of law.
Are you saying he conducted an independent review?
I believe that he was obligated under 6G to do that, and yes, he did do that. He conducted that review. He was not obligated to address every one of the 140 findings of fact that may have been made below.
Well, he actually, he expressly said he's not going to do that. He can draw his or her ultimate conclusions. I mean, this is a very typical way. Somebody makes the findings of fact, and then you draw your own ultimate conclusions. That's the standard Kafka used.
And, Your Honor, I believe what he did on the opportunity claim was to make conclusions on both facts and law as to what was going on. And I want to call the Court's attention to the following quote, which was before Judge Kafker and is part of the record before this Court on this subject. This is a quote from Attorney Oleski that was taken at his deposition as part of the 6F discovery in this case, which was limited discovery. I'm quoting from his deposition, page 47, lines 6 to 13. Quote, I was always concerned that the fact that my clients had gone ahead and acquired the other two properties, which were physically approximate to 23 East, was a fact that would be or could be portrayed to be harmful in a fiduciary duty context unless it was in the context of a full exposition of all facts. Mr. Oleski was always concerned. He used the term harmful in a fiduciary duty context.
Unless it was. Don't forget the second part of that sentence.
I mean,
Unless it
isn't
was
that just repeating what he just told me when I said to him, why didn't you move for summary judgment?
Yes, Your Honor. Our point here that if he was always concerned about this, he had the opportunity, if he had a clear contractual clause, he had the opportunity to move to dismiss, move to summary judgment. He, in essence, said at another point in his deposition, I didn't do that because I was aware that there were countervailing contractual clauses, which was something also before Judge Kafker, that there were countervailing clauses. In addition, there was the case law.
Before you get there, how can a limited partner have standing to complain about the failure to furnish the partnership with a opportunity? Isn't that a right that belongs to the partnership and not to a limited partner?
I believe that the right goes beyond that, Your Honor. And
Is there any case law that says that a limited partner is entitled to bring a corporate opportunity or partnership opportunity claim as opposed to bringing it as a derivative claim on behalf of the partnership?
Let me suggest this, Your Honor. On that particular issue, when the lower court said it should have been brought as a derivative claim, even Mr. Oleski at his deposition said she was wrong on that because this was a partnership and not a corporation. The law on derivative claims only applies to corporation, and this was not something that he followed up on in the appeal because he conceded that she was wrong on that issue. But following up on the more general point, I think that the Wartsky case is very clear. It was one of the reasons why both Judge Kafker and the full appeals court panel found that the law was unsettled. Yes, Chokel came out later on. You understand Chokel came out after the case was tried. But before Chokel, there was Blank on one side. We would argue that Blank was a very limited holding. On the other side, there was the Meehan case. There was also the Wartsky case, a case that we have cited in our brief, the First Circuit applying Massachusetts law in 1991, saying that in the partnership context, all the other cases dealt with corporations. In the partnership context, you cannot have a contractual clause to nullify a duty to disclose. You cannot do that by contract. So we felt, quite frankly, we should have won the underlying appeal on that. The court ruled differently, but the same court, the same single justice, the same appeals court said to us and said in the 6F ruling, okay, you lost the appeal, but there were at least sufficient weighty issues that were presented that were sufficient here.
In the two questions, Mr.
Yes, Your
Green.
Honor.
In the First Circuit case, first of all, the scope the scope of a fiduciary duty within a partnership, I think nobody would suggest that you can contract out from that fiduciary obligation. But in the First Circuit case, was there a limitation on, was there an express provision as to what the general partners could do with respect to other opportunities?
There was an attempt, Your Honor, to, in essence, limit a fiduciary duty, and I want to quote
No,
the
but
Warski
here we
case.
don't have an attempt to limit a fiduciary duty. What we have is an attempt to limit quite clearly what the scope of the partnership is, and then you have an express provision, which is a little unusual in saying, and by the way, you, the general partners, can go off and develop other pieces of land.
I think there are two different issues at play with respect, Your Honor. The first issue, and both issues, by the way, were sufficiently gray issues to support our notion here that this was a completely genuine claim. But on the first issue, there were countervailing provisions in the partnership. There are some provisions that Mr. Oleski relied on that said this is limited to this. There were other provisions that broadened this. And as I said, Mr. Oleski stated in his deposition, we didn't move to dismiss, in part because he understood that there were countervailing provisions. Then there's the second point, Your Honor. Even if there were only one set of provisions in the partnership agreement to say it's limited to this respect, the plaintiffs relied on the notion that there was still a duty to disclose under the partnership, under partnership law.
Of
and
what?
in particular,
Of every business opportunity?
of, in essence, related business opportunities, Your Honor.
So what, so that means every adjacent parcel?
An adjacent parcel, Your Honor, we would suggest is certainly a sufficiently related opportunity. As far as we're concerned, it didn't have to be expressly adjacent. But in this particular case...
But, I mean, what's the limit? I mean, just think of it from a practical point of view, correct? Let's assume that there's a duty to disclose. What's the harm if there's no disclosure? I mean, what comes with the duty to disclose?
What comes with the duty to disclose, Your Honor, is something that is just well recognized under law. You owe your partners a fiduciary duty.
To let them into the next deal?
In essence, to disclose to them material facts.
But what is material if the partnership agreement... I mean, I'm really having a hard time understanding you, because I've got an agreement that everybody's sophisticated. You know, we're not talking about the spouse who didn't know what was going on. You've got business partners saying, we're going to get together for this deal. They are teaming up with well-known developers, and they are saying, but we don't have any rights with respect to your other deals. Why is it a breach of fiduciary duty if you're dealing with other deals?
Again, Your Honor, it's two issues. There were other provisions in the partnership agreement
So
which suggested that it went beyond the deal. But beyond that...
What's the specific language? Not what's the clause, but what's the specific language that says, if it's another deal, not 23 East Street, I have a duty to disclose?
We have cited in our
Yes.
brief, Your Honor, several provisions of the partnership agreement that read our way that we believe went beyond this. But just getting back to your question on the breach of fiduciary duty, it is really a case-by-case analysis, Your Honor, as to what has to be disclosed. As far as we're concerned, this was way on one side of any bright line that could be set as to disclosure being made. And what is instructive is that in Warski it says, and I'm quoting, even if the partnership agreement can be interpreted as defendant claims, it cannot nullify the fiduciary duty owed by Bedford to the partnership.
Okay, but the question, I guess, is, let's assume there was a duty to disclose. So they disclose to the partnership. What leads from that? The limited partners are limited partners. They can't do anything.
The limited partners may well be able to do something, Your Honor. In this case, it is absolutely
What can a
undisputed.
limited partner
what?
do
What can they do?
without losing his position, his tax position as a limited partner?
The limited partner can say, wait a second, you just can't go out and take an opportunity for your own majority partners. This was, in essence, something that the majority was doing without bringing it into the partnership, doing it as an opportunity that should have come into the partnership pursuant to the other provisions in the agreement. And the limited partners, if they had known, and there's absolutely no dispute that this was not disclosed to them, could have run into court and could have said, time out, stop. We are entitled to share in something that should have come in to the entire partnership.
And if they had done that, you think they would have won?
Your Honor, I'm not sure what would have happened, but I will tell you that they had a colorable claim as to their ability to say that they were entitled to share in this.
All right.
And this is when we-
And going back to your answer to my previous question, let me quote from you from Smith versus Marshall Field, 40 Mass Ave Court 625, 1996. A limited partner may bring a derivative action for the benefit of the limited partnership, citing GLC 109, Section 56. Because the claim asserted in a derivative action is that which rightfully belongs to the limited partnership, the right to maintain a derivative action can be no greater than or different from the right of the limited partnership to maintain the action for which relief is now sought derivatively. Are you saying that that case has been overruled?
I'm not saying that, Your Honor. I'm saying that a limited partner is not required to bring a derivative claim. A limited partner has every right to bring a direct claim. And there's nothing in that case to suggest otherwise. That is one vehicle, but there is no reason why a limited partner cannot bring its own claim. And again, even Mr. Oleski concedes that point.
Mr. Green, forgive me for going back, but I'm looking at the single justice's decision on the fees, and I see that he starts off at the bottom of page 2, based on the local applicable law, the trial judge's ultimate conclusion that you couldn't have any reasonable belief that they had any claims is not supported, okay? Then we go to Chokel, and if you know anything, regardless of what the rights of a limited partner are, corporations and partnerships are just different. Agreed?
Agreed.
Agreed. So that's irrelevant. Then he goes on to say, in determining the scope of the general partner's fiduciary, the language was interpreted as permitting blah, 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 and then, but he says, the interplay of the various contractual provisions, and doesn't tell me which ones he's talking about.
There were various contractual provisions, Your Honor, that have been recited in the parties' briefs. We can provide the exact...
No, I haven't, but I really need you to point. I've got language that says I can go do other developments. You're saying not next door, and I'm saying tell me where in the agreement it says not next door. I mean, broadly interpreted.
The partnership agreement gave the partnership the right to make investments in other real estate. If this were a true single-purpose real estate partnership, there would have been no reason to have included that language. But especially when they went next door and went to a party buying these properties, selling all 3 properties, including the property in question, not disclosing this fact, this was something that gave rise to this lawsuit. It was a completely colorable lawsuit, Your Honor, because the single justice had all this before him, because the appeals court panel in essence endorsed his ruling pursuant to their ruling on the other decision in the case. We believe that this court should affirm both rulings and find that this case was properly brought and that the 231-6F standard was not met.
Mr. Green, I just want to go back
Certainly,
to the beginning of your oral argument. The last clause of Section 6G says that the single justice, I'm reading in single justice, may withdraw or amend any finding of the trial court, I'm inserting that, or reduce or rescind any award when in its judgment the facts so warrant. Notwithstanding de novo review, does a single justice of the appeals court have to address the findings of the trial court made under Section 6F and specifically reject any, if any are going to be rejected?
I don't believe that the statute itself, Your Honor, calls for the single justice to have to go through one by one and accept or reject every finding. I think to the contrary, a de novo review means that the single justice is doing it on his own and isn't sitting as an appeals court judge, is sitting de novo and makes his determinations, and that's what was done here. So
but he has specifically said, I'm not upsetting any findings. I just think her conclusions are wrong.
He has said that the conclusions are wrong, but we believe, Your Honor, that implicit in his ruling, and certainly if you look at the footnote in the other ruling, the court has done more than that. The court has said
which footnote?
There were contrary provisions in the partnership, there was a nondisclosure, and in essence making some key implicit factual assumptions that underlay the ruling, and that they were entitled to do that under the de novo review.
Just one last thing, could you just help me? Footnote 3 in which opinion?
Footnote 3 in the appeals court opinion, which is the other part of this whole appeal. I
The
think
the Mallets one?
Yes.
Yes.
I don't see that, but that's my fault.
Footnote 3 on page 2, I'll just read it. The absence of advance notice regarding the defendant's services provided some justification for the pursuit of this claim. Here we're talking not about the opportunity claim, we're talking about the fees claim, so-called related parties claim. And we believe that the court was in essence saying that a second claim was valid, and clearly if 2 of the 3 were valid, then there certainly is no argument here that all or substantially all was met. Above, the appeals court said that they were satisfied with the court's ruling under 6F. They endorsed his ruling above. Thank you, Your Honor.
Thank you, Mr. Green.